Hello, guys. Welcome to the debut edition of our podcast, Intellectual Property and Trade Nexus Podcast. Thank you for joining me. Today will be our debut edition, so hold on just for a minute before we begin this all-important podcast. Let me check the video. Okay. So welcome again. Welcome, guys. I see Mr. Decker, Ali, Komejala. Thanks for joining. So today is like I said, welcome to my debut podcast. This is the IP, the Intellectual Property and Trade Nexus Podcast, where intellectual property meets international trade. So on this podcast, we will be discussing issues related to innovation, intellectual property that has to do with the property of the mind, the property of creativity, the property that has to do with concept and technical know-how. So thank you guys for joining. To go straight into the meat of the matter, I would like to begin by making a brief introduction. For those of you that don't know me, my name is Tom Bwaka Tombekai. I have a background in intellectual property and international trade. I used to work at the Ministry of Commerce and Industry, where I served as Assistant Director for Price Analysis and Marketing. While there, I also served as Intellectual Property and Trade Policy Analyst. So I worked, my career background span for a little over a decade plus. So basically, I would like to use this podcast as a medium to share my experience, my expertise, my knowledge working in international trade and working with intellectual property related protection, management, and all issues related to the multilateral trading system. So that's a brief introduction. I have a background in intellectual property. I work at the Ministry of Commerce and Industry, Republic of Liberia. I also did an internship at the World Trade Organization in Geneva for roughly a year. And I was exposed to a lot of opportunities engaging in direct derivative-related work, working with thematic areas of derivative accession, international trade-related issues, trade facilitation, import-export related issues. So I garnered a wealth of experience working at the World Trade Organization. I also had the opportunity to go through some lengthy professional training at the World Intellectual Property Organization, also in Geneva. And I come with, I would not like to, so like I said, I was part of the technical committee responsible for the accession of Liberia derivative membership and the post-accession implementation. So basically what that means is that Liberia was in the process of becoming a member of the World Trade Organization. So in Liberia, domestically, at the Ministry of Commerce and other technical institutions, we formed a technical team, and I was one of the members of that team that led to Liberia acceding to the World Trade Organization. And after Liberia succeeded in becoming a full-fledged member of the World Trade Organization, it had an obligation. Liberia is presently a member, so there are still obligations that Liberia needs to meet. So we worked in that direction while we were serving at the Ministry of Commerce and Industry. So basically, this podcast will be a place for me to share my experience. Eventually, I will have to bring others, professionals, other colleagues that have worked in the field of intellectual property and international trade, WTO issues, UNTAC, RTC, the ITC, all these institutions that support and foster international trade and innovation. So that's a brief introduction. Education-wise, I hold a Bachelor's of Science in Management from the African Methodist Episcopal Zion University. So I'm a veteran Zionite. Also, I was fortunate to have earned a second degree, a Bachelor of Arts in Political Science from the state-run institution, the Microcosm of Intelligentsia, the University of Liberia, my alma mater. So that's the second degree then. And lastly, I was also opportune to have studied at the University of Turin in Italy, where I earned a Master of Laws in Intellectual Property. So basically that is enough for me, enough information about me. So that's a brief introduction. I would like to move quickly into the meat of the matter that we are discussing here today, which is intellectual property and international trade. But today we will begin with patents. When you hear patent, what does patent means? So we'll begin with the history of patent. So back in 1474 in Western Europe, specifically in Venice, in the city of Venice, and this was during the Renaissance period where a lot of innovations were being made. People were discussing on new inventions, how to improve the well-being of society, how to improve the quality of life, how to improve productivity, how to come up with new devices and equipment. So this were around the period of the Renaissance period, so there were a lot of cultural development as well as intellectual, as well innovative development going on. So in 1474 in Venice, stakeholders, politicians, those in the private sector thought it was important for there to be certain level of protection for patents for those that were creating a lot of inventions in society. And they said, in order for us to award these people some level of protection, we need to craft a document, a policy framework to protect, to give them certain rights and privileges. So in Venice was the epic center of innovation, innovation in architecture, innovation in medicines, in the pharmaceutical, innovation with transportation. These were the period when trains were the major utility for transport. So this was the period when innovation was really explored in Western Europe. So they came out with what we refer to as the first patent statute. So the first patent statute set the foundation for the patent system. So, like I said, in Venice, the stakeholders within the innovation space, politicians, those in private sector, all decided we need a policy framework to protect innovation. And they crafted what we refer to as the first patent statute. They said going forward, from 1474 going forward, that all those with new and ingenious contrivance will be given protection, that we will give them certain rights and privileges to incentivize innovation that will be productive to improve life and society. So after innovation was being explored in Europe, 150 years after, the United Kingdom followed suit with what we refer to as the statute of monopoly. So 150 years after innovations were being protected in Western Europe, particularly in Venice, and in 1474, United Kingdom followed suit 150 years later and came out with the Statute of Monopoly. And the Statute of Monopoly was basically to protect. Firstly, the Statute of Monopoly was basically prohibit all monopolies, because back then in the days, the Queen Elizabeth was very notorious for giving monopolies to her cronies, to those favorites to the crown. So Queen Elizabeth, the monarch, was very notorious of giving monopolies that granted rights to certain individuals within the British territory to have rights to provide salt, maybe it could be tea, it could be textile, and some maybe a product. But these monopolies were given to people favorable to the crown, and they were solely responsible to provide or to distribute certain products within the British Kingdom. So the Statute of Monopoly first came and said, no, we will prohibit the crown or Queen Elizabeth from giving any monopolies to those favorable to her. And now we will set a new stage wherein any individual within the United Kingdom that have a new and ingenious contrivance or new creation, a new product, a new equipment, or a new service that is technical enough, we will give those individuals the right, and that right is going to be encapsulated within a patent. So that's how they started to give patents out to those that are innovating new products. So that's how the Statute of Monopoly came to be. It first abolished all patents that were given to those favorable to the crown and made it possible and for the general public to participate in the patent system. So the Statute of Monopoly ended the influence of crown distributing monopolies to her cronies, and then set the stage for new and ingenious contrivance to be given that right to have a patent. So after that period, we see that in Western Europe and in the United Kingdom, both in Venice and in London, patent protection is taking place. We have the first statute in place in Europe. We have the statute of monopoly in the United Kingdom. So the issue that was trending back then was newness. Anything, any ingenious contrivance that is productive enough to enhance health, to enhance agriculture, to enhance transportation will be protected. So in order to be beneficial and innovator to receive a patent, you need to come out with a new and ingenious contrivance. So after those statutes were enforced and people were encouraged to participate in the patent system, new innovations were coming, and the society as a whole was benefiting from those innovations. More people were encouraged and the patent system started. That period was the foundation of the patent system. So what is patent? So what patent simply means public or open for public inspection. So anytime you hear someone say he or she or a company has a patent, in the context of the government that grants that protection to that individual or business, they are simply saying patent is public or is open for public inspection. And back in the days, there were two types of patent. Two types of patents. We had what we refer to as the letters patent and the closed patents. So the letter patents were those patents that were of public nature. So take for example, they were a documentation with the inscription, shining bold letters, gold, sometimes golden, silver, but shining bold letters with the inscription of certain rights and privileges that were given to an individual or a company because of a specific innovation that they produced to society. And that person went to the government and said, this is my innovation. And the government went through all the check and balances and ascertained that this individual met all the requirements for that innovation to be approved. And the patent application was approved and went through the process and were given that documentation. So letters patent were open to the public, so everybody could see it and could understand that this individual is given this right. Take for example, in the military, there could also be patent was also given back then in the military. If I was in the military and I was promoted from one rank to another, maybe from a sergeant to a captain, that documentation, that patent will be given to me with the inscription that X, Y, and Z, Mr. Tom Tombeka receives this promotion, this rank, and he is the patent holder to that rank. And the second type of patent, which we refer to as the letters closed, is the same documentation, but this one is of a private nature. So it's not open to the public. That's why we say letter closed, because it's of private nature and there are certain confidential information that cannot be exposed to the public. But all these documents, the two patents, all these documentation were kept by the British government or in the European, in Western Europe, all those territories that had a patent system that would provide this documentation to the inventor and keep the documentation. So these were the two patents, the letters patents, which was of public nature, and the letters clause of a private nature. So patents were given to the military. There were patents, a grant of a royal charter, for example, in Great Britain could be patented, and patent down interventions. Inventions as well could be patented. So during this period, there was also a discussion on what procedures could be most appropriate for the patent system. So there were discussions among countries on which approach to use for the patent system. So if I am an inventor and I want to file my patent, what approach would I use as an inventor? And what approach was available to me within that territory I had invented or new innovation? So there were two procedures for filing a patent. The first procedure was what we refer to as the registration system. So the registration system provided a bureaucratic space where, when you are in a specific territory, you go to the government and you give a description of your patent. This is my invention. This is a device. It does X, Y, and Z. I am the original patent. This is the process. So you basically give a description of your patent. You go to the patent office or the responsible entity within that country, and you provide a description, you give a documentation, and in England, you will receive a patent. You receive your application will go through the process, and you get a rubber stamp documentation, and you get a patent immediately. So the registration system was very simple and easy to operate. If you are an inventor, you take a description of your patent to the patent office, and the staff there will go through all the descriptions that you are laying. They will give you a documentation, a rubber stamp documentation, and immediately presenting you as a legal patent holder. That was the first system, the registration system. The second system is what we call the examination system. So in the examination system, countries differ on which system you whether the registration or the examination. But this examination system, you go through the same procedure, you give a description of your innovation, you submit it to the responsible bureau for that action, and the government then will examine your description and do a technical analysis to make a determination whether your innovation merits patent. So the examination system lays out a procedure wherein an inventor will provide a description of his or her invention, and the government will do a technical analysis to determine as whether that innovation merits the technical requirement or merits of patent. So these were the two systems, the registration system and the examination system. But just to discuss the pros and cons of the both systems, in the registration system, it was much easier to operate as a government. Because all you needed was maybe a group of less than 10 to 20 staff that we register. We go through the description of the patent, rubber stamp it, and immediately give the patent out to the inventor. But in the registration system, the point is that there were a lot of low quality inventions that were being granted patent because there were no way to examine, to do a technical analysis to know whether the invention merits a patent. Merits of patent. There was no analysis done with the registration system. So there were a lot of low quality inventions within the registration system. The pros and cons of the examination system is that the examination system was cost intensive to operate for the government because you needed a whole group of technical staff to do a critical analysis of the invention, the applications for patent, to assess the technical merits of the invention, and to make a determination whether that invention merited a patent or to reject the patent application of said invention. So these are the pros and cons. The government needed a lot of money in running the bureau, responsible with a lot of technical staff, and that's the point of the examination system. The pro is that there are a lot of high quality inventions within the examination system, because if you filed an application for a patent, your application will be placed on the market. The market will meet the requirement, the technical requirement are spelled out. The technical requirement, if you never met, your application will be rejected. So there are a lot of high quality inventions within the examination system. So these were the two procedures for filing a patent, and the pros and cons is that the registration system was less costly to operate, but there were a lot of low quality inventions. The examination system is cost intensive to operate, but a lot of high quality inventions. So these were the pros and cons of the both system. Now we move to what I consider one of the critical part of the system in terms of the scope of patentability. So the scope of patentability, what that means is that what should be patented, what invention should be given, say, right, or what inventor or institution, company, or business should be given the right to say, I have invention, or I awarded a patent from the government. So what should be invented? So there were disagreement among countries on what should be patented and what should not be patented. So there are many issues, but two stood out the most, and these were the methods of medical diagnosis and the methods of medical treatment. So some countries of that these two areas should set a standard, should set the scope for patentability, that these areas we can decide on whether to patent innovation within this area or not. But particularly the United States did not allow the methods of medical diagnosis it doesn't apply within the United States or in Japan. Depends on country that allow the method of medical diagnosis and the method of medical treatment. But in the US, it doesn't apply. So there were different disagreements upon which method or approach to use. So going forward in the 1800s, there was a movement to abolish patent. So some people in Germany, politicians, business people, those in the private sector, critical minds felt that the patent system needed to be abolished, that it was not worth being in existence. So they wanted for patents to be abolished. So the rationale behind their debate is that the general public needed to have access to innovations. Everyone in society needed to benefit from innovation. So prohibiting or giving one individual business or company the right to have patent, prohibit other people within society from exploiting their invention. They felt it was unfair to the general well-being of society, and they requested and demanded that the patent system and patent protection be abolished. But in Germany, like I said, this happened in Germany where they call for the abolition of the patent system, but it never materialized because Germany maintained the patent system, and today Germany happens to be one of the technology superpower. So that debate was the general public to have access to inventions, everybody need to use it, so there should be no patent, nobody should protect patent. But the German government insisted that they were going to keep the patent system, and today Germany happens to be one of the technology superpower in the world. Moving forward to the 19th century, where the foundation of the patent system is from, issues among countries was moving toward harmonization. So there were a lot of inventions, there were incentives to innovate, because if you keep off for new invention or new device or new equipment that is ingenious, is new, is not obvious, but it's very new, and it's a very new idea, it's productive for society, for the well-being or entertainment, you would be given the right as a people, and you have the right to restrict other people using that. You would have the authority to give people the right to sell the product, use it, to sell it, to exploit it, to advance it. You as a particular will be the only individual responsible with sell it. So if, take for example, I want to look at the aesthetic nature of this iPhone, and if I was the only individual that produced this smartphone, I would have the right, the only one to sell it. If other people decide they will come to me, so there was a lack of authority when you received a patent given to you as an individual company when you receive a patent. So the argument for the abolition of the patent system was that the patent system was discussing the issue of harmonization, how to harmonize the party laws in various countries. Take for example, I live in Liberia. Our applications were in Malta, and I saw a very new device that has the capacity to produce a lot of, let's say, our in the water producing business, the mineral water business, and this equipment could produce maybe a million bottles of mineral water a day. And I wanted to export from Malta to Liberia. There were a lot of bureaucratic bottlenecks that would make it difficult for me to export said product from Malta to Liberia. Or should, in case if I had a country clause somewhere in local and I went for a vacation in Brazil, that country clause, and they were interested in it, they were fascinated by the design of that country clause, and they wanted those products, they needed shirts, they needed garments, suits for some set product, which is the country clause. For me to export that country clause from somewhere in Folia, over the free port, to export it to Brazil, that bureaucratic bottleneck that would stop me, that would discourage me as being an inventor or creator to trade. So in the patent system in the 19th century, the focus was that we need to harmonize the laws, the regulations in the patent system to allow easy trade facilitation and easy access to innovation around the world. So people were traveling, there were a lot of travel going on, people were moving out of the world, and trade was on. So globalization basically forced the patent system to form to harmonization. A semblance of uniformity within the patent laws, the patent policies and regulations to ensure the force of trade and to ensure that the productivity of more invention and innovative products. So globalization pushed the patent system to harmonize its laws, regulations, and policies within the 19th century. So when that happened, people were able to easily trade from one country to another country and create. So productivity in the innovation space was more, because you need to have more product. If you have a new device and you want to sell it to 5 countries, you need to increase the productivity of your products and as well as the quantity of the products. So all those influence the harmonization of the patent system. So going forward, I would just like to move strictly into some of the existing patent laws, the current laws that are presently enforced to patent protection, patent management, and the promotion of innovation. So I will begin from the late 1994 with the Rural Round. So the Rural Round was basically with member states and it will focus on the Yoga run of 1994 is what I consider one of the largest trade negotiations that took place. But it took place under the framework of the General Agreement on Tariffs and Trade. So they basically had this big conference, a lot of countries attended, and were discussing issues around tariffs and trade. And patent happened to be one of the issues that were being discussed. So patent, the Yoga encapsulated patent protection. So Yoga happens to be one of the international agreement to facilitate patent protection as well as the management of patent. The second agreement I would like to look at is the TRIPS, which is the trade-related aspect of intellectual property rights. So the trade-related aspect of intellectual property is an agreement that focuses on enhancing intellectual property protection and as well as linking it with international trade. So how can you protect your invention or your innovation, and how can it be traded across country? How can we facilitate the process of international and intellectual property protection? So that's the TRIPS agreement of 1995. So this agreement basically set minimum standards for the WTO members. So take for example, Republic Tomika. I have an interest in acceding or becoming a full-fledged member of the World Trade Organization. I proceed to Geneva to commence my WTO accession process. As part of the package of becoming a WTO member, the TRIPS agreement provides minimum standards that I should meet as a prospective member of the WTO to become a full-fledged member of the World Trade Organization. So in order for me to be a member of the World Trade Organization, the TRIPS agreement is and the agreement set out minimum standards set minimum standards, and these minimum standards focuses on the eligibility for protection. If I am an inventor, I live in Italy to Rio. So I'm an inventor, I live in Italy to Rio, and I want to seek patent protection in Italy. Italy being a member of the WTO meets the trade agreement with set minimum standards. Italy then gave me an eligibility requirements and say, Mr. Inventor, these are requirements for Italy to give your invention protection in the territory of Italy. These are the eligibility for protection. So you as an inventor, if your invention meets those eligibility requirements, then your patent application is accepted and you are given minimum rights. So your responsibility is to meet the minimum requirements, eligibility requirements as an inventor. Then the Italian government will give you minimum rights for your patent protection within said territory. So, moving forward, let me progress. The next international agreement I want to discuss is the Paris Convention, which happens to be the first agreement in 1994, Euro round of 1994, agreement in 1995. So these are recent agreements. So now because some of the past agreements that are still in force with the Paris Convention of 1883. So the Paris Convention of 1883 discussed industrial property. Industrial property simply means properties that are of industrial nature. The technical features of these properties are of industrial nature. So in order to meet them, and there are a lot of subjects, intellectual property subjects on industrial property. We have patents, we have trademarks, we have industrial designs, we have geographical indications, and we have unfair competition and other related subjects. But these are the key intellectual property subjects on industrial property. So the Paris Convention of 1883 was about patenting domestically and patenting internationally. What are the requirements set out for you to go to the patent system domestically? Because one thing I want us to know is that patent protection is territorial. So in order to gain a patent, you have to file application within a country, a specific country, and you have to rely on that country to protect your patent, and should in case of any eventuality of infringement, you are relying on that country to enforce through the courts to adjudicate whatsoever of infringement that your patent have been affected, or should in case you are sued, you can go through the court system. So patent is territorial, the application is territorial, and the enforcement of patent is territorial. So the Paris Conventions spelled out focuses on industrial property, and patent happens to be a key component of the Paris Conventions, stipulating the requirements to patent or obtain a patent domestically to a country, and how to obtain a patent internationally. So patenting domestically and internationally, that was the focus and remains the focus of the Paris Convention. So the next agreement or agreement about patent laws or patent agreements, the next agreement is the Patent Cooperation Treaty of 1970. So the Patent Cooperation Treaty came after the Paris Convention, but the Patent Cooperation Treaty now focuses on filing an international patent. So there were difficulties experienced by inventors or innovators that in order, if I have an invention and I wanted to protect it in 5 different countries, I will have to enter each of the countries individually to file my patent. To protect my patent, I have to go through the 5 systems. And each of the countries have different requirements, they have different approaches, patents. So it was a difficult thing for inventors to protecting the patent in different countries. But the Paris filing for patents in different countries at the same time, it was cost intensive and financial preparation for patents or inventors. So the patent cooperation treaty made it possible for an inventor to file an international patent. So with the patent cooperation treaty provided the platform where an inventor can file an international patent simultaneously in many countries, and countries that are signatories to the patent cooperation treaty. So in case like you are actually a member of the patent cooperation treaty. So in case, for example, I'm an inventor living in Liberia, Monrovia, I want to file an international patent application. I go to the Liberia Intellectual Property Office using the PCT, which is the Patent Cooperation Treaty. I file an international patent application. The Liberia Intellectual Property Office will help me to facilitate my application, maybe through a repo or depending on what region, to the African Regional Intellectual Property Office or through the World Intellectual Property Office. The Liberia Intellectual Property will guide me in the process of filing my patent application. So internationally, I can file my application. I can file one application for 5 countries, 10 countries, 20 countries, depending on where I want to conduct business. So the Patent Cooperation Treaty provided the platform where inventors can file a patent concomitantly in several countries that are signatories to the Patent Cooperation Treaty. So this further enhance the facilitation of patent protection, patent application within the patent system. So the first benefit is that it reduces the stress in filing patents in individual countries, and it has one application and file in several countries simultaneously or concomitantly, and that application will take effect in all those countries that are designated: Germany, France, Italy, Malta. Depending on which country you business where your information is needed. So that was the patent cooperation treaty. It provided an opportunity for inventors to file a patent application and designate several countries simultaneously. So before going further, let to emphatically state here that there is no international patent law. There is nothing called an international patent law. So the patent protection is territorial. So each country has an individual. Each country makes the determination on what laws to use within their territory to determine the nature of the patents, laws, policy, and system within it. So each country makes that determination. They have their own laws for patents, but those laws were subscribed in whatsoever international organization. Should in case they are member of the World Organization, they have the TRIPS agreement, the Paris Convention on Patent Cooperation Treaty, if they are members of the World Intellectual Property Organization. domestic territory to be, but that should be in alignment with all these multilateral organizations you are a member of. That maybe law that conforms to international, but specifically organizations that are member of. If you are a member of the World Trade Organization or the World Economic Organization, you are making a practice with your partner. Partner should be in sync with the international laws. So this is how it works for the patent system. So each country makes a determination of the patent system, the laws, the policy, the regulation. Each country makes a determination on the enforcement and protection of patent within their territory. That is how the patent system works. So, in case of infringement, for your application, let's say you file your patent application at the bureau, you go through the process, and you are accepted, you are given legal documentation affirming that you are a legal patent holder. Or liability, you see the system, the courts are there, the business courts responsible to adjudicate business related issue, intellectual property. The whole is the Ministry of Commerce and Industry, and under the Ministry of Commerce and Industry, that is the responsible entity in Liberia. Under it, you have the Liberia Intellectual Property Office that do copyrights and do all the intellectual property related issues. Then you have for enforcement of your patent right, you have the Ministry of Justice, where the courts are set up to adjudicate business or trade related cases. So that's the whole system. So each country make the full determination of how the patent system works, but it should be in alignment with all the international organizations that they are full-fledged members of. So moving forward, I would also like to state here that there have been discussions, although there are no international patent law that to say we have one body governing patent all over the world. There's no such thing presently. However, there have been discussions and conversations in the works surrounding specifically in Europe. There have been discussions. This has been a European solution to international patent protections. So I consider it to be discussions and conversation concerning patent protection internationally, but from a European perspective. So in Europe, the European countries have been discussing the establishment of the Unified Patent Code. So this code is basically to ensure the enforcement of patent internationally, where all disputes to go for patent infringement resolution. So the whole system of the Unified Patent System, it will be for Europe, and should in case other members countries have to join, but it was basically started with Europe. So discussion held, but then when Brexit took place, it undermined the progress of the prospect of these discussions. So there are some deadlock on how to proceed because the Brexit undermines the whole prospect of the unified patent code. However, countries are still discussing the possibility that since Brexit have long been over, other European countries to come together to still pursue the establishment of unified patent code. But there are also other alternatives to patent protection. In case you are members of the World Trade Organization can have bilateral agreement, multilateral, plurilateral agreements to make a determination of mutual beneficial bilateral or multilateral plurilateral agreement. Liberia, Brazil, and Argentina can have bilateral agreement stipulating what rights and privileges will be protected in 3 of these territorial member states. So our opportunity to have attended some bilateral meeting where members were discussing interest in it could be in patent protection or intellectual protection, but not in a whole. There will be specific issues that you intend to protect in this country. But most, like I said, bilateral, so that means a mutually beneficial agreement to the parties within said agreement. So this is thank you for following. This is our debut episode of the Intellectual Property and Trade Nexus Podcast. I have to support this. This is my first edition. Sorry if I took too long to explain some of the things and you don't understand, but this is the first step, and we will improve, and eventually we'll have some professional colleagues here to discuss intellectual. This topic is not your regular everyday topic. I know people are moving politics now. We are in elections period, but this is a very professional topic that we are discussing. We are discussing intellectual property protection, intellectual property management, development, promotion, and international trade facilitation. So this is what this forum podcast is all about. So it's the forum for innovation and trade. So thank you for joining. Thank you for your support. This is the first podcast. I know there will be some technical issues. I'm seeing comments. Let me check your comments and see, get some feedback. This is difficult. Get the microphone and all the necessary gadgets. Things will improve eventually, and the quality of the podcast will improve eventually. But please consider me. This is the first DB podcast. If you notice the time and also but we resolve them eventually, improve the quality of the podcast. Then let me check the comments. Okay. So guys, sorry for the quality of audio. We are going to work on that to improve that. Sorry, I know you found some difficult glitches in the background, but we are going to work on that. The next episode will be something much better. Thank you for following. We ask you to continue support this. Come we have spare time. Please share, for like. We are basically going to focus on intellectual property and international trade. So this is our focus. This is what in our professional career. This is where we have knowledge, expertise, and so we will be providing share knowledge and expertise to discuss issues in international trade, governance, and intellectual property management. So that's the focus. Thank you, Vafi Holmes. Senior comrade, Chairman Mao. Thank you, Biba. Doing something, just after this, something from our passion. We have passion for this. We have worked in it. So we found time to discuss it. Intellectual property. Thank you guys for following. We look forward to the next podcast. Thank you for your support. Five films. Emmanuel Kabi. Oh, my baby says, thank you for the methods. Emmanuel, oh, my scouts and thank you for following. The next edition will try to improve the quality of the audio and even the background. Thank you. We are going to be discussing, like I said, it's a forum for innovations and international trade. So we will be discussing issues related to intellectual property, WTO, what intellectual property organization, the laws, the regulations. We're discussing today, of course, the patent law of innovation, the historicity of, and so we'll be discussing different topics, geographic indications, trademarks, trade secret, industrial design, unfair competition, just a diverse facilitation, fishery, the just a diverse issues related to intellectual property and international trade. So we have passion for this. Make some time. Now, time we come here maybe twice or 3 times a month to discuss. Madam Anna Scott. Manja Momo. Great. Thank you for the support. Thank you for all your support. Thank you. Bye. Never come soon. We'll try to work on the quality of the sound. Thanks, guys. Okay, bye, guys. Let me see the time. I want to know the time.